As we death of 17-year-old Jordan Davis is raising more questions about this widely publicized Jacksonville homicide.
An affidavit released today offers new details on why the accused killer, Michael Dunn, told police he was frightened for his life the night he opened fire on Davis and 3 other teens in an SUV. Dunn is charged with first-degree murder. He's awaiting a judge's ruling on his request yesterday that bond be set so he can be released while he waits to stand trial. New in that affidavit, after Dunn told police he saw the barrel of a shotgun inside the SUV, police told him there was no weapon in the vehicle. Dunn then told the detectives he saw either a barrel or a stick. Joining us now from our newsroom is Jacksonville Attorney Gene Nichols. Gene, let me ask you first, when was the last time a judge here in Jacksonville granted bail for a defendant charged with first-degree murder?
Well, Tom, very simple. Based upon the facts that we have in this case, I'm not sure if anybody can remember a judge granting a bail in a situation like this when there's been a first-degree murder charge and so many other charges of attempted first-degree murder.
Now, let me play for you, Gene, a comment from Dunn's lawyer about his side's burden of proof in trying to convince the jury his client opened fire in self-defense.
We don't have to prove there's a gun in the car. That's been the misnomer from day one. All we have to prove is that Mr. Dunn had reasonable fear that he was going to be imminently in danger of his life or great bodily harm, and that he only shot in self-defense, and that's justifiable use of force.
Do you agree with Mr. Strolla?
Tom, sort of. I agree with his premise. The point that he does not make that we need to pay attention to is the word reasonable. This is not about what Dunn saw, what Dunn felt, but whether or not a reasonable person in Dunn's circumstance would have felt the same way. So the statement that he makes basically conforms with the law, but we do have to consider that this is a reasonable or an objective standard and not necessarily what Dunn was thinking at the time.
What do you make of Dunn's statement to the police in the affidavit about seeing a stick?
Well, Tom, it is going to be a huge part about this case. Dunn has made a statement to the police that we have seen that either he saw a gun or a stick. I'm not sure what stick he could have possibly seen that would have led him to believe that he was in fear of an imminent injury or death. So it's going to be an issue that Mr. Strolla is going to have to overcome, that he believed a stick could have caused his death. Obviously, it's going to be a huge issue in this case.
And finally, Gene, can you remember a murder case here in Jacksonville that has received so much publicity before the trial starts, with the possible exception of Christian Fernandez?
Well, Tom, other than that exception, I don't think any of us can remember a case that has gotten the publicity and the press that this one has. Of course, we have such a tragic loss in this case, and everything that's happened with the stand your ground law and self-defense law in the state of Florida, this has become a hot case, not only here in Jacksonville, but throughout the state, throughout the country, and we will continue to see it throughout the press all the way until the time that Mr. Dunn finally goes to trial, through trial, and then whatever the jury verdict is at that time.
Gene, thank you very much for your insights. Gene Nichols joining us from our newsroom tonight. Florida Stand Your Ground law has been mentioned in the Jordan Davis shooting, as Gene just said, and it was also, of course, brought up quite a bit in the Trayvon Martin shooting. Tonight, according to a new Quinnipiac poll, a majority of Florida voters approve of the law. 56% of those surveyed said they support the right to fight back with deadly force if they feel threatened. 36% are opposed. Among African-American voters, 26% said they approve of the law, while 62% were against it. And among women voters, supporters edged opponents 51 to 40%. A task force named by Governor Scott last year studied Stand Your Ground and concluded there is no need for major changes in the law.